Here is 3 things you need to know about the 491 visa under the sponsored family stream. First of all, you can only apply if you have a skills assessment in an occupation on the medium to long-term occupation list. Second of all, to apply, you must have an eligible family member who lives in a regional postcode in Australia. You, yourself, the applicant, doesn't necessarily need to be living in regional at the time. You will need to live in regional after your visa is granted. And lastly, even though they call it family sponsor stream, it is still invitation based and you'll only get invited when they have an invitation round. Someone asked me, if you get a student visa refusal, will it affect your 485 TR visa? So the answer is yes and no, but let me explain. There are certain requirements for the 485 TR visa, and they mainly are that you must have held a student visa within the last 6 months and completed your qualifications. So if your student visa was refused and you hadn't gone to hearing yet and you hadn't had a chance to win your case, then you don't meet the requirements for the 485 TR visa. So that's what makes the appeal process really important now for student visa refusals. However, if you had a student visa refusal and you were able to go to hearing and win your case before you finish off your course and the ART remit your decision back to the Department of Home Affairs, your student visa will be granted and therefore you should meet the requirements for this 485 TR visa. This came up on my feed and I wanted to make a video about it. It says British couple are facing deportation over MS diagnosis. It doesn't say what visa they applied for, but reading this article, I assume that they applied for a skilled visa, possibly a 190 or a 189. And that's because the DHA refused their visa because the health cost exceeded the significant cost threshold. And this is a random picture, by the way, I don't know who this is. It looks like they got the visa refusal and they appealed this to the ART. However, the tribunal can only assess against the regulations. When you apply for a skilled visa, there is no waiver for the health costs. You either meet it or you don't. So after the ART affirmed their decision, it looks like they've gone ahead and applied for ministerial intervention. When you apply for ministerial intervention, you lodge your application, then you have to apply for a bridging visa E, because applying for ministerial intervention is not actually a visa application. So you have to continually apply for bridging visa E's. And that's why they say they can't leave the country here. Now, only the minister can make this decision, not even their delegates. And you can imagine how many applications the minister probably needs to consider. We actually have some applications ourselves that have been sitting there for years. If this is the case for you, it'd be really important to seek legal advice. There are visas that have health waivers and some that don't. So it would be important to make a decision of which one is better to apply for. If your employer ever threatens to cancel your visa, look at this visa option. Workplace exploitation is not okay in Australia, and the department allows you to apply for a visa, and the department allows you to stay in Australia while the claim is being assessed. So I actually hear this a lot. You've been sponsored by your employer, and a lot is on the line. Sometimes your PR is on the line, and your employer threatens to cancel your visa if you don't do ABC, or you're pressured to work more hours, or you feel obligated to do it. If this has happened to you, reach out to an immigration lawyer or agent to see if you're eligible to pursue a workplace claim. And once you're given the certification for this, you can apply for the 408 Workplace Justice Visa.